Good evening and welcome to the urban.co.uk and the National Landlord Association's webinar on rent arrears. We're going to go through the definition of rent arrears, some good practice, and then section 21, section 8 and some court proceedings and some questions answered along the way. A bit about urban.co.uk. We are the UK's leading online letting agent and have been about since 2008, helping thousands of landlords to save thousands of pounds. And the NLA is the UK's largest landlord association, providing all the tools and support for the ever increasingly difficult task of being a landlord. Okay, so let's get started. I'd like to welcome John Coyne from the NLA, who is going to guide us through today's webinar. John, welcome. And can you start by telling us a bit about you and why you are qualified to speak on the subject?
Thank you. My name's John Coyne. I'm a portfolio landlord and have been for 19 years. I'm also a qualified barrister. I have over the years dealt with many of the issues that I believe that letting agencies deal with around the country. I'm also a consultant and advisor for the National Landlords Association. So both in my own practice of my own property business and dealing with clients of the National Landlords Association, I've had to deal with a broad spectrum of the situations that occur through being a landlord.
John, thanks for that. Many landlords ask us to talk about arrears, but what's the actual definition of arrears and the first steps a landlord should take?
Well, that's a very good question. The definition of a rent arrears is that the contract defines when rent is lawfully due, usually monthly in advance. According to the assured short-hold tenancies of by far the majority of landlords, rent has to be paid in the agreed manner at the agreed time and in the agreed amount. So in other words, if the rent is due on the first of the month and it is, to pick a figure out of the air, £300 a month, and it's not paid on the second, technically that is rent arrears. How to deal with rent arrears? Well, the first thing to suggest is that it should be addressed quite quickly. Very often there are reasons why the tenant is in arrears, and usually contact sooner rather than later will help address the situation. My experience of this is some tenants are just forgetful. If they have a situation that's agreed where they pay money into an account on a monthly basis, although a standing order is better, then sometimes a phone call will remind them. The difficulty with letting it go too long is that if a landlord does nothing for a couple of weeks, then effectively this will mean the next monthly payment will become due, and effectively we'll have to try and find 2 months of rent arrears, 2 months of rent in 2 weeks.
Is there any good proactive steps you advise taking that can calm a situation before becoming more official?
Certainly, and I always advise to try the informal approach. I think the first thing to do is quite literally pick up the phone to the tenant and say that, I'm your landlord, I'm sure this is an oversight, but just to remind you the rent is not, has not been paid, and find out the reasons why. I personally had a case where it transpired a little down the line. The rent had been paid, but the bank had allocated it to the wrong account, and this was a banking error that was found out later on. But irrespective of the situation, it is better to have the conversation sooner rather than later. And regarding the ways to do it, I think it's important to also put in writing that the reminder for the rent arrears is made, because if at a later time the situation goes to court, a landlord can show they've taken all reasonable steps before actually going to court to try and address the situation.
Is that important to show those reasonable steps? Will a court be looking for those steps to be taken, or can you just go straight into the serving notices?
That's a very good question. The first thing to say is that most tenancy agreements do say that rent is lawfully due on the stated time, whether demanded or not. So if nothing is done, all it will mean is that the landlord has perhaps allowed the situation to escalate without taking early action. In terms of if the situation does go to court, it won't affect the landlord's efficacy in terms of getting a judgment or getting a possession order, because the judge will look at, is this rent due? Clearly, sometimes the worst place to go for justice is actually a court of law, and it is better to try and resolve the situation by agreement. I personally have only been to court with my own tenants once in 19 years, and that's with over 40 properties. I always take the approach that it's better to meet the tenant, have a sit down, even meet them in a neutral area, like a coffee shop. I've done that a few times, and try and have a discussion as to what's going on, and see if the tenant is in difficulties, how it can be helped. I genuinely believe that if you agree to take what rent they can afford and try and resolve it later, that 70% of the rent is better than no percent of the rent. And just to try and reassure the tenants, because the worst thing that can happen is that the barriers go down and communication stops. And I think that it should be that the landlord takes the approach that this is a joint problem, and let's try and resolve it together in an amicable fashion.
Going back to what you said about demanding rent, is it possible that the tenants could claim that you were going to give them a freebie, for example, and that would hold up in court? Do you need to make sure your demands are provable?
It has been raised in court. It's a very tenuous legal defence to non-payment of rent. Usually the starting position in terms of evidence in court is that any document produced is the legally correct document stating the position at the time of the court hearing, unless proven otherwise. So if a tenancy agreement is produced and it says rent due on the first of the month, that is the starting position. If a landlord has agreed a reduction in rent, or has agreed that the tenant should only pay less than the full market rent for a period until they get themselves back on their feet, that should be evidenced in writing. But in cases of doubt, or if raised by the tenant, in almost all circumstances the landlord would find for the landlord, unless the tenant could show in writing that there has been a written variation of the contract. So it wouldn't really cause a major problem for a landlord going to court to try and recover rent arrears.
So let's move on to Section 8 and Section 21 notices. There's often a lot of confusion with which notice should be served and how to serve it. In fact, it's one of the most common questions we get asked as an agency. Can you tell us a bit more about these notices, please?
Okay, we'll deal with Section 21 first. The Section 21 notice is a no-fault notice giving the landlord an unfettered right to get their property back. There is no substantive defence to a Section 21, only a procedural one. And by that I mean that the application to the court, if it goes that far, may be dismissed if there's a mistake in the paperwork. There are strict rules about the Section 21 and the way it can be served. For example, it cannot be served within the first 4 months of a new tenancy. It cannot be served to end the fixed term before the natural end of that fixed term according to the initial contract. And it will give the tenant 2 months to leave the property. And now, with the changes that came in quite recently, in actually October the 1st, 2015, the Section 21 notice does not now have to end on the last day of a tenancy period, as long as the tenant has 2 clear calendar months, usually with a few days added on if it's sent by post. The Section 8 notice is completely different, because that is a notice informing the tenant that there has been a breach of tenancy. Something like 99% of all Section 8 notices served are when there are 2 months' rent, A, lawfully due, and B, unpaid. The Section 8 notice gives the tenant 14 days to remedy the breach, i.e. pay back the rent arrears or come to some sort of arrangement. If not, on day 15, the landlord can instigate court proceedings. If there are 2 months' rent lawfully due and unpaid on the day that the Section 8 is served and on the day of the court hearing, the court, as a mandatory duty, will award possession to the landlord and the rent arrears and the cost of the application. They can also be served at the same time, together at the same day, and the landlord may then choose, if necessary, which one to go to court on.
If the tenant pays a small amount on day 13, does that mean the notice is void and you have to start again?
That's another very good question, and one that gets asked at the NLA advice line quite regularly. The first thing to say is that when the Section 8 notice is served, as well as ground 8, which is the 2 months ground, there are 17 grounds, by the way, for possession, we always suggest that the landlord also cites in the notice grounds 10 and 11 as well as ground 8. Grounds 10 and 11 are discretionary grounds, whereas ground 8 is a mandatory ground. And grounds 10 and 11 cover some rent lawfully due and rent persistently delayed. So even if the tenant pays some rent or most of it before the court date, and on the day of the hearing there is still less than 2 months rent lawfully due and unpaid, then obviously ground 8 will not apply. However, all is not lost, because the landlord can then ask the court to make a suspended possession order based upon terms the court will give based upon the circumstances of the tenant. So in other words, if the court orders the tenant to pay the full rent plus £100 a month until all of the arrears are discharged, and then says, dependent upon that, there is a suspended possession order, one of two things will happen. Eventually the landlord will get all the arrears, but if the tenant breaches the order for a suspended possession, then the landlord can immediately ask for a bailiff order, because the suspended possession order will then automatically become a possession order absolute, which means the landlord will have immediate possession and can seek enforcement. So all is not lost, and it is a common question, and it's a common thing that tenants try to do, but there is, by doing that, a way to still get possession, or at worst, or best even, all of the rent arrears.
Sounds easier to file a Section 21. Will I be able to get some rent back if I do that?
Again, another good question, and one that's often asked. The Section 21 process is involved with possession only and nothing else. What a landlord will get back is the cost of the application, which is £355, and the court will make an order to say the tenant must actually pay that back to the landlord. Whether they actually get it is another story entirely, but the court will make an order that the cost of the application will be paid back by the tenant. So the Section 21 deals with possession only, and the Section 8 deals with possession and rent arrears and the cost of the application as well. So the Section 8 notice is, if you like, all singing, all dancing. However, many landlords do prefer to go to court on Section 21 because there is absolutely no defence to the Section 21, providing all the correct administrative and procedural legal requirements are met in the whole process up to the day of the court hearing. Whereas with Section 8, there is a potential counterclaim if the tenant, for example, alleges disrepair.
Can I hedge my bets and serve both notices?
Yes, both notices can be served at the same time. However, the landlord will need to decide which one to go to court on. So it's an either or. So the landlord can then make a decision based upon what happens next. It's quite common for Section 8 to produce some rent, and we actually had a case last year where there was £3,000 of rent owed. The landlord served the Section 8 and the Section 21 at the same time, and a week later a cheque for £3,000 turned up to the landlord, which surprisingly actually cleared. However, the landlord wanted possession of the property in any event because there had been issues other than rent arrears around the tenant: low-level antisocial behaviour, drunken behaviour, loud noise at night, disturbing other residents. So the landlord successfully went to court on Section 21 and got possession. because the Section 8 was no longer valid because all of the rent had been paid. So it sometimes is prudent, and we do advise in any and all events to serve both of them at the same time.
Okay, so there's a lot of anxiety around serving notices from landlords properly and legally. What is the foolproof way of legally serving a notice that will stand up in court?
Okay, again, another very good question. As one long-time practicing barrister said to me once about court procedure, if you want a guarantee, get a toaster. There's no real guarantee at all. However, a way that will stand up in court, there are three of them. The first one is you meet the tenant and ask them to sign that they have received the document, be it Section 8 or Section 21, or whatever the document would be. So if you have a document or they sign your copy of the Section 8 or the Section 21, and we always advise, by the way, landlords must keep copies of every document they serve and every letter they send out. But if you have a signed document where the signature on that document matches the signature on the assured short hold tenancy agreement, then you have a 100% foolproof method of service because the tenant has agreed they've received it. The second way to make sure that there is proof of service that will stand up in a court of law is certificate of posting. Now, if the landlord goes into a post office and hands over the document they're sending to the tenant, they will get a certificate to say it's gone into the postal service. It's deemed to have been lawfully received 2 working days later and does not require a signature. The third method is to go to the property with a witness and put the document in an envelope and push it through the front door of the property. The witness can then draft a document known as a witness statement to say that they have received or seen the landlord put the document through the letterbox. And it would say something as simple as this: at 2:08 p.m, I saw whoever it was put a Section 8 or 21 in an envelope and put it through the front door of the property known as. A witness statement merely states what the observer sees with their 5 senses. And again, that will stand up. The question that's often asked is, who can the observer be? Can it be a relative or a friend? There are certain elements of the law where procedurally there has to be certain classes of individuals, such as the drafting of a will. There are certain laid down rules. But for something like the serving of a legal notice on a residential address or a commercial address, the rules are the person need be A, sane, B, sober, and C, over 18. So it's perfectly acceptable to have a friend, relative, husband, spouse to be an observer.
Now, I know you can't serve the notices via email, but is there any advantage to sending a copy via email once you've done one of the other methods?
That is correct. As things stand at the moment, legally, a document cannot be served by email. However, yes, it is an effective mechanism because it firms things up. To send a copy by email would add to the weight, if I may put it that way, of the whole process. So whereas the tenant can perhaps claim, well, maybe I didn't get the letter or it wasn't put in the door, if they've also had an email and frankly even responded to the email, then that will be supportive of one of the main 3 ways to serve the notice. One other quick point: sometimes landlords will send a document by registered mail which requires a signature. Now, if the tenant does sign for it, that's all well and good, but often they don't, and a card is put in the door, and 2 weeks later the letter is returned back to the landlord. If that's the case, it has not been lawfully served. So unless the landlord is certain that the tenant or somebody will sign for the document, it's better to be a bit wary about sending notices by registered post.
Okay, so I've legally served one of my notices, or both of my notices now. What next? So once I've served my notice, how long do I give it until I move to court proceedings? And then how do I move to court proceedings?
Okay, again, another very good question. We'll deal with Section 21 first. The Section 21 notice gives the tenant a minimum of 2 months to vacate the property. Now, this may sound like stating the obvious, but the landlord should go and check that the tenant is still in the property before proceeding. We literally have had cases where the landlord has gone to court, got possession, even bailiffs a couple of months down the line, and the next door neighbour suddenly says, but they've moved out a couple of months ago. So do check that the tenant is still in the property. So with Section 21, the tenant is still in the property. There's a specific prescribed court form to fill out called a court form N5B. That's court form N5B. It can be found literally by Googling court form N5B and it will actually come up. That form needs to be filled in and taken to the nearest county court to the property with a court fee of £355, which the court will order to be paid back by the tenant to the landlord at a later stage. What will happen then is the court will write to both the landlord and the tenant once the form is filled in and taken to the court, and the tenant will have a right to raise a defence. Now, as I said earlier, there is no substantive defence to a Section 21, but if the tenant raises a defence, there will be a hearing and they will need to come up with a good defence to stay in the property. Just to reiterate, there is no defence to a Section 21. However, if the landlord has made the mistake of not protecting the deposit, getting the date wrong, or making a procedural or administrative error in the paperwork, the case will be dismissed. So the correct paperwork and the correct procedure correctly followed will always 100% grant a possession order, and usually the judge will give the tenant 14 days to vacate. If the tenant does not respond within the 14 days that they're given after the paperwork has been served with the to the court, then the landlord can ask for a possession order without a hearing. Now, when the court writes back to the landlord, there will be paperwork in there stating the date that the tenant must respond by. The landlord quite literally on day 15 rings the court, and the court will then deal with the issue of has there been a response from the tenant. If there has not been a response by the tenant, the landlord can make an application to have a possession order granted without a hearing. And how to do that, once again, will be in the paperwork sent in by the court to the landlord. And it's literally a case of filling out a small form for which there is no fee. A few weeks later, the judge procedurally and administratively in court will grant a possession order without a hearing, giving the tenant 14 days to vacate. So that's the process for Section 21.
Can I just make a point on Section 21 as well?
Yeah.
If you don't send or have proof that you've given your tenant the how to rent booklet, even if you've done the gas safety but you haven't got proof that you've provided the gas safety, same with EPC, these are all reasons that could to essentially void your right to serve a Section 21 in court. Is that correct?
That is correct, absolutely correct. These are a few of the procedural issues that the landlord needs to get right. Now, if in doubt, what is suggested, and this has not been in front of the courts, but many legal websites and many legal firms whose opinion I respect all suggest, and I agree with this, if a landlord finds out, I am not sure if I have actually served the paperwork, as long as that paperwork is served again with the Section 21, most opinions agree that it will stand up in court. The reason why is that in the legislation, what it says is that the EPC, the gas safety certificate, and the prescribed information, mind you, if the prescribed information is not served within 30 days, there will be an issue and it will be not allowed. But with the other documents, if they are served with the Section 21, then the court should allow possession, because it doesn't mention a timeline for the EPC, the How to Rent guide and the gas safety. Unfortunately, the position with the prescribed information for the tenancy deposit regulations is different. If it's not served within 30 days, it's incapable of later rectification. But even then, there is a way around it. If the landlord returns the deposit to the tenant prior to serving the Section 21 notice, then the Section 21 process and the application will succeed. So a very good point on the documents. Moving on to Section 8, the Section 8 is a separate standalone eviction process. So the Section 8 has been served and there's been no response after 14 days. On day 15, the landlord can fill out two court forms. They are Court Form N for Nobody 5 or Court Form N for Nobody 119. And again, they can both be Googled and they will come up. As with the N5B form for the Section 21 application, it's a case of just filling in the form. Also, the Section 8 possession process can be done online by going on to Possession Claim Online. The process is exactly the same, except one is done the paper way and one is done the online version. Both are as quick as each other, except with the Possession Claim Online, there will be a court date given much quicker than if it's done in the paperwork day, but that date will not be any sooner than the ordinary date for doing it with the paperwork. So the two forms are filled in and given to the nearest county court, again to the property. With the Section 8 process, there has to be a hearing. It cannot be done without a hearing, and in 6 to 8 weeks later, maybe longer depending on the court, there will be a court hearing. It will only last for about 10 minutes. It will be fairly informal, and the judge will be concerned with one question and one question only. On the day of the hearing, is there a minimum of 2 months' rent lawfully due and unpaid? If the answer is yes, the judge will do three things. They will grant possession to the landlord, giving the tenant 14 days to leave. They will grant all of the rent arrears up to that day, and they will also grant the cost of the application, which is usually £355. In addition, if the landlord has had to get to the court from a distance and the landlord produces receipts for a train fare, that will also be added on as costs as well. So those are the two main ways of getting possession. It should be further mentioned, in about 90% of the cases with Section 8 and the hearing, the tenant does not turn up, because the only defence is that the tenant has paid the money. And if a tenant turns up and states they've paid the money, the legal and evidential burden will move to the tenant, and the tenant will have to produce evidence of bank statements, receipts or witness statements to say that the money has been paid, which clearly they won't be able to do. And the possession order normally goes through quite quickly without the tenant being present.
Okay, well, this wealth of information you're providing, John, is generating quite a few questions. We can't obviously answer them all, but we can get through a few. One that's coming up quite a lot is, when do proceedings move to bailiffs, and how do I do this?
Okay, again, another very good and very common question, and obviously one of concern for landlords. The bailiffs can be applied for the day after the court order for possession expires. So if hypothetically there was a court order saying that the tenant has to vacate within 14 days, which ends on July the 20th, then on July the 21st, if the tenant is still in the property, an application may be made to the county court bailiffs. Now, the county court bailiffs will take, again, maybe 8 to 10 weeks. There is a delay because of the court cutbacks and the amount of hearings that the courts actually are having to deal with. So it will take that long. However, once the bailiffs are appointed, and the fee to do so is £121, by the way, the form to fill in is form N325, which is a very straightforward one-page form. The information already for the court hearing will be at the court already, so it's just a form to request the bailiffs to turn up. The landlord will then be contacted by the bailiffs nearer the time, and once the bailiffs do attend, it really is last chance saloon for the tenant, because they are allowed to use reasonable force to evict. Usually they don't, they will call the police, and there will be a letter to the tenant saying that the bailiffs will be attending on this day, please pack up and leave, because if they don't, then they may be physically removed by the police.
Okay, another question coming up a lot here is there any difference in tenants receiving housing benefits on the bailiffs or any other of the procedures that we've discussed?
There is no difference in terms of procedure or the requirements of the tenancy agreement, whether they are on housing benefit or not. Even if rent is paid by a third party, which clearly housing benefit, or known now as local housing allowance, is actually paid by a third party, it doesn't detract from the fact that the contract, the assured short hold tenancy, is between the landlord and the tenant. It is well known that local housing allowance doesn't cover the full rent, but this does not mean that the full rent on the contract is lawfully due. It is an area of difficulty because many tenants do not seem to understand that because the rent is paid by a third party and is less than the global figure mentioned on the tenancy agreement, that they still have to make up the difference with what is known as top-up. So whether it's a student letting, a professional, even a high-end professional, or someone on housing benefit, makes no difference regarding the actual process.
Okay, John, well, thank you very much for joining us today. We're running out of time now. Just time for one more final thoughts. Do you have any key takeaways for the landlords listening today?
Yes. One of the points I often make, and it's something that I practice myself, is that many of these problems with possessions can be done if greater care is taken up front. So always reference the tenants very thoroughly, always get national insurance numbers, always ask for identification, if necessary get a guarantor. Never let a tenant in without getting a 1 month's rent and 1 month's deposit, and make sure everything is placed before going ahead, because many of the situations that we deal with at the NLA advice line can actually have been greatly mitigated or prevented by greater care being taken and more work being done at the very beginning of the tenancy in terms of referencing thoroughly. And so that would be my final point, to make sure it's all done properly at the beginning. And my experience has been, since in our property business we tightened up our procedures, the problems have been less and less.
Yep, and certainly here at urban.co.uk and the NLA, we can help you ensure that you are doing things correctly. Well, thanks again for joining us today, John. It's been an insightful and interesting presentation. If your questions were not answered, please watch this space. We will post a follow-up onto the Landlord University and the NLA blog, which will be mailed out to you at your registered email address. If you have any feedback about the presentation, we'd love to hear it, so please email info@urban.co.uk. Well, thank you again, and we'll see you next time.